Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage.
Today we cover Keathley versus Buddy Ayers Construction. Decided June 11th, 2026. 9-0, Justice Jackson wrote for a unanimous court. The ruling. Courts must look at all the circumstances surrounding a bankruptcy debtor's misdisclosure before deciding whether judicial estoppel, a doctrine that punishes parties for flip-flopping positions in court, blocks that debtor's lawsuit entirely. The Fifth Circuit's narrower, two-factor test got thrown out.
And two justices wrote separately to raise an even bigger question, whether this doctrine should exist in federal courts at all.
We previewed this case, and as you may recall from that preview episode, the fight was always this. Do courts get to look at everything, or do they stop at just two checklist items? The Supreme Court answered that today. Let's get into it.
Before we do, your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know.
Let's rewind to December 2019. Thomas Keathley and his wife file a Chapter 13 bankruptcy petition in Arkansas federal court. Chapter 13 lets you keep your property while you pay creditors back over 3 to 5 years through a court-supervised plan. The bankruptcy court confirmed their repayment plan in April 2020. 100% repayment to creditors, interest-free, over 5 years. The Keathleys just needed to stay on the plan and pay it out. Then August 2021, Keathley gets in a car accident in Mississippi. The driver worked for Buddy Ayers Construction. Keathley hires a personal injury attorney. He tells his bankruptcy lawyer about the accident and that he intends to sue. And here's where things went sideways.
Neither Keathley nor his bankruptcy lawyer updated the bankruptcy court forms to disclose the new lawsuit.
Correct. Bankruptcy schedules require debtors to list all claims against third parties, accidents, rights to sue, even before a lawsuit gets filed. Debtors sign those forms under penalty of perjury. Keathley filed his personal injury suit in December 2021, still without looping in the bankruptcy court.
So, the bankruptcy court had no idea the lawsuit existed.
Until March 2023, when Buddy Ayers Construction moved for summary judgment, that's a motion to win the case without a full trial, based on judicial estoppel. Their argument, Keathley told the bankruptcy court he had no claims against third parties by staying silent, then turned around and sued in a different court. Inconsistent positions. Game over.
And Keathley immediately corrected the record.
The moment he got served with that motion, he filed an amended bankruptcy schedule disclosing his personal injury claims. He submitted sworn statements, his own and his bankruptcy lawyers. He stated he believed he had done everything he needed to do after informing his lawyer of the accident. His bankruptcy counsel confirmed Keathley received no benefit monetarily or otherwise from the nondisclosure. No creditor ever objected. And those creditors collected 100% of what they were owed.
That sounds like a paperwork mistake, not a scheme.
That's the argument. But under Fifth Circuit precedent, it didn't matter. The district court applied a two-factor test. If the debtor knew the facts underlying the claim, and if the debtor had a potential financial motive to conceal it, judicial estoppel applies. Keathley conceitedly knew about the accident, and the court decided he had a hypothetical motive. If creditors had known about the lawsuit, they might have demanded interest on the repayment plan. Two factors met. Summary judgment for Buddy Ayers. The Fifth Circuit affirmed, though Judge Haynes concurred separately and called the omission an honest mistake, expressing doubt the doctrine's goals got served here.
So 5 other circuits, the 4th, 6th, 7th, 9th, and 11th, look at all the circumstances. The 5th and 10th just stop at 2 factors. That circuit split, courts across the country dividing on exactly this question, got the Supreme Court's attention. Cert granted in 2025 to resolve it. At oral argument back in March, Justice Jackson pressed Keathley's lawyer, Gregory Gare, directly. What if a debtor intended to omit something, just not for financial gain? Does motive matter at all?
Gare's answer, what matters is whether the debtor intentionally adopted the position that no claim exists, not the particular reason behind it. And that requires a court to actually look at the evidence, which the Fifth Circuit's test never allowed.
Justice Alito pushed back hard on that. He asked, doesn't a legal duty to disclose plus a financial interest in staying quiet create a pretty strong presumption of intentional concealment?
Gare said no, not in this context. Not when no creditor objected, the error got corrected immediately, and the omission produced zero actual benefit. Justice Barrett made the sharpest point of the day. The bankruptcy court, after Keathley disclosed the claim, never sanctioned him. Nobody even asked for sanctions. If the court directly supervising the case saw no threat to its integrity, why should a district court in a separate proceeding wipe out the entire lawsuit?
That's a tough question for Buddy Ayers to answer.
Respondent's lawyer, William J., tried, arguing that the benefit to Keathley came earlier in the bankruptcy itself, not at the time of disclosure, but it didn't gain traction with the bench. The questioning ran heavily in Keathley's direction throughout.
Let's get into the court's opinion. Justice Jackson's opinion moves in 3 clean steps. Step 1, judicial estoppel functions as an equitable doctrine, meaning a fairness-based tool, not a mechanical rule. The court's 2001 decision in New Hampshire versus Maine, a boundary dispute between those 2 states, set up the modern framework and left open whether inadvertence could serve as an exception. The court assumed, without deciding, that judicial estoppel can apply in bankruptcy and that inadvertence matters. Then it went straight to the Fifth Circuit's error.
The test failed in 2 directions, too rigid and too broad.
Exactly. Too rigid. The Fifth Circuit only let courts look at 2 circumstances. It blocked all other evidence. But equity, by design, demands flexibility. The court pointed to Holmberg versus Armbrecht, a 1946 case, for the rule that equitable doctrines eschew mechanical rules and depend on flexibility. And Holland versus Florida, a 2010 case about habeas corpus deadlines, confirmed that equitable inquiries must account for all relevant facts and circumstances, case by case.
And too broad, because those 2 factors will almost always cut against the debtor. Debtors almost always know about their own accidents. Debtors almost always have some theoretical benefit from nondisclosure. Creditors might demand more if they knew. The Fifth Circuit's own case law acknowledged the motive factor is almost always met. So the test marketed itself as an exception, but functioned as a near automatic rule. You can't call something an exception when it applies to virtually every case.
It's like a coupon that says restrictions apply and then restricts out every product in the store.
Yep. Courts must instead ask, did the omission truly result from inadvertence or mistake? That means looking at everything. When the debtor learned of the claim, whether the error got corrected promptly, whether the debtor received actual benefit, what the debtor's lawyer knew, and what local bankruptcy court practice looked like for amending schedules.
The court vacated the Fifth Circuit's decision and sent it back. Vacated and remanded. Thrown out and returned for a do-over under the right standard. Now, the concurrences. Justice Thomas, joined by Justice Gorsuch, fully joined the majority and then asked a much larger question. Where does federal court's authority to apply judicial estoppel come from at all? The doctrine entered the mainstream only in recent decades. It lacks any basis in a federal statute, any federal rule of civil procedure, or any traditional inherent court power. At oral argument, Justice Gorsuch called it a relatively new invention and pointed out the court really has exactly one opinion on the subject, New Hampshire. That's thin support for a doctrine federal courts now apply broadly.
So Thomas and Gorsuch said, in a future case, the whole doctrine merits a closer look. That's an open invitation. If the right case arrives, at least 2 justices want to re-examine whether federal courts should apply judicial estoppel at all.
And Justice Sotomayor took it in a different direction. Sotomayor wrote to address a specific concern she raised at argument. When a bankruptcy case still sits open, judicial estoppel may never make sense. Here's why. The party who benefits from dismissing the debtor's lawsuit isn't a creditor. It's the tortfeasor, the defendant who caused the injury and had nothing to do with the bankruptcy. At the time, Keathley's lawsuit got dismissed. His family still owed creditors about 4 more years of payments. Any judgment Keathley recovered could have gone toward paying those creditors faster or in full. Judicial estoppel vaporized that potential asset.
And the bankruptcy court already had better tools. Sanctions, plan modification, converting the case to a different bankruptcy chapter, even a perjury referral. Judicial estoppel delivers one remedy and one only: dismissal of the tort claim, which harms the exact people the doctrine claims to protect.
All right, what this actually means. For anyone going through bankruptcy who later gets hurt in an accident, this ruling removes the trapdoor. Under the old Fifth Circuit rule, forgetting to update a form cost you your entire lawsuit, full stop, even if you corrected the error immediately and produced no actual benefit from the silence. Now courts must look at the real picture.
For personal injury defendants in states that fall under circuits running the Fifth Circuit's old test, they lose the automatic kill switch. pointing to a bankruptcy filing in the plaintiff's history no longer ends the case. The defendant must actually argue the totality of the facts supports intentional concealment. And 3 open questions will drive future litigation. 1. Does judicial estoppel belong in bankruptcy at all? The court assumed yes without deciding. 2. Should it ever apply when the bankruptcy still sits open? Sotomayor laid out a strong argument for never. 3. What factors belong in the totality analysis? The Fifth Circuit on remand will start building that list, and other circuits will follow.
Plus, Thomas and Gorsuch waiting in reserve to challenge the whole doctrine. Bottom line, a unanimous court told the Fifth Circuit, you turned a fairness tool into an automatic trap for debtors who made honest mistakes. Keathley gets a real hearing now. Whether he wins on remand depends on how the facts look under the full analysis, but the deck no longer stacks against him before the inquiry even starts.
That's a big deal for anyone who's ever filed for bankruptcy and then had life hand them something unexpected, which describes a lot of people.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And if you've been sitting on that 5-star review, today's case just proved that failing to update your paperwork can cost you everything. Don't be Keathley with the forms. Go rate us.
Legal life lessons from the High Court Report. Talk to you soon.